Hello, everyone. Myself, Nikhil Ramdev, Senior Associate at MRP Advisory. I'm the host for today. And today we have a very, very special guest with us, Miss Nikshita Niranjan. She's a Deputy Registrar at IAMC Hyderabad. Thank you, Nikshita, for taking out time and being with us today.
Well,
Before
thank you, Nick.
So, for those unfamiliar, can you briefly explain the role and responsibilities of a deputy registrar within an institutional arbitration institution?
Absolutely, yeah. So this appointment is actually very recent. It's been only 2 months now. But the role of deputy registrar at an institution is at the core, it is the entire management. So it is the management of the administration of arbitration and mediation cases, where we essentially act as the bridge between parties, arbitrators, the center itself, and other stakeholders. And the ultimate goal is to ensure proceedings move smoothly and efficiently, right? But it's with being a young institution, it's not just case management. It's also like I'm involved in a lot of shaping the institutional policy. So it's creating systems, protocols, driving a lot of strategic partnerships with law firms, with corporates, with academic institutions, government organizations. So we working at the center sort of feels like you're the focal point of building this ecosystem and bringing about awareness. So a big part of my role is outward facing, I would say. It's we host a lot of trainings. We're focusing on capacity building at the moment. And we've also been doing a lot of flagship events, webinars to just build awareness to the various sectors about ADR. So yeah, that's and every day is very different, and that's the beauty of it. You're sort of balancing, I would say, procedural precision, but with a people first approach. So yeah, and now right now, like a lot of people are talking about mediation and arbitration than ever before. So the whole landscape is buzzing, conversations are shifting. Yeah, so it's a very interesting place to be.
Thank you. It's really quite a strategic role that you have. And the so on that note, as you know, India's arbitration landscape has undergone significant changes in recent years. From your perspective, what are the most impactful reforms and how have they influenced the caseload at IAMC?
Okay, so IMC is we are now 3 years in, and what I'd say is, yeah, the last decade especially, there's been a lot of tremendous change in, say, arbitration and even mediation. In fact, there are a lot of reforms that have come in. So if we break it down, let's say the legislative reforms itself, if you start from the 2015 amendment, where the 12-month deadline for passing the arbitration award became a priority. So efficiency and the timelines became very important. Then the 2019 amendment said that, only after the pleadings are done, the timeline would start. So it gave a more practical advantage there. And also, international arbitrations got some breathing space after the 2019 amendment, since they are now exempt from the very strict interpretation of the timeline. So after that, I would say even the now that we have the draft 2024 bill of the arbitration bill, which proposes something really big, and this is huge for IMC because it allows institutions like us to set up our own appellate tribunals to hear award challenges, and the entire process is sort of giving parties an option to be a court-free option under Section 34, I would say. So that is on the legislative reforms, and we have the Mediation Act and the even the recent notification from the Ministry of Finance, which has given guidelines. Right. So although the Mediation Act is not notified, it's brought in a lot of change for institutions because we understand the role we are expected to play. And even on the judicial front, I think there's a lot of support from the judiciary when it comes to less judicial interference in matters. For example, I would say like the Amazon case itself, where the Supreme Court gave emergency arbitration a stamp of approval, even though it's not in the act, and that is something IAMC also has in our rules. So we provide for emergency arbitration, right? So these things have basically created a very fertile ground for institutions like IAMC. And because they're focusing on structure, on efficiency, and the main thing, which is the credibility. So introduction of these strict timelines for awards, even under Section 29A, has encouraged people to choose institutions now. So, for example, I would say in IAMC, arbitrators are appointed within 30 days. Whereas, when you apply, go for a Section 11 application appointment, it takes significantly longer. So, especially with respect to appointments, we've received court has referred matters to the institutions to take care of the appointment as well. So, yeah, I think that's so. If you look at it, I think Section 34 of the Act, which lays down the grounds for setting aside an award, quite of them are related to procedural irregularities, such as, invalid agreement, lack of a proper notice, whether the subject matter is arbitrable, the composition of the tribunal. So, all these issues can really be avoided with institutional arbitration, where an efficient team at IMC can manage the case to case and ensure that all these irregularities are taken care of. So I would say, yeah, the credibility is most important, and because of these reforms, we are able to really bring in those protocols and changes and increase our caseload, although very steadily. Yeah, that's on the reforms.
Thank you. That's really insightful. As you have told us about the legislative and policy changes, I'm sure with that, a lot of challenges also come. So, how does IAMC address the challenges of ensuring efficiency and timeliness in arbitration proceedings, especially with a growing caseload?
Yeah, so I would say so at the stage where IMC is at is we've set up our internal protocols with a lot of care. So if you make like we make sure that an arbitration case is handled smoothly and on time. And instead of looking at it as, one big case, we've broken it down into smaller manageable steps. So even smaller timelines, like whether it's, filing the request or by when will the arbitrator be appointed, all these things, it's broken down for the case managers so that they'll be able to stay on track and complete each stage within that set timeline. So another important thing is that, we're also using a lot of technical tools now that are available for record keeping, for the case tracking. So that ensures efficiency. And we have regular meetings to discuss the status of cases and address challenges. For example, when a party is non-responsive or there are any procedural difficulties, our case managers are people who are equipped, who are legal professionals, and they're well equipped to identify these issues, and they know how to handle them. So the clear demarcation of roles and timelines help us administer these cases. For instance, we have a case administrator who basically focuses on monitoring timelines and ensuring that all records are properly maintained. And then we have the case managers who oversee the administration, ensure strict compliance with the procedural rules. And for our hybrid and online hearings, we have a IT person who's dedicated for every time there's a online or hybrid meeting, he's present to ensure there are no difficulties on that front. And even after an award is passed, the registrar, our rules allow the registrar to scrutinize the award itself. So any, if it's not, if they ensure that it's in proper format and it's a well-reasoned award. So this is how we're trying to ensure efficiency and make sure that there are no procedural irregularities as far as possible from our end.
Oh, that's great. So I have a follow-up question on that. So could you walk us through the general procedure for initiating arbitration at IAMC and what are the key steps parties should be aware of?
Okay, so it's actually very simple. We've made it, it's very party friendly because we have a lot of parties that do come in without a counsel as well. So they can simply just drop us an email at our secretariat ID or even give us a written request and then they have to just fill up one arbitration request form. So it's as soon as it it asks you simple questions like the party details, a short summary of the dispute, the claim amount, preliminary claim amount, and a copy of the arbitration agreement or clause. So, and if it's been referred by a court, then the court order is also needed to be provided. So, once all these things are given, then the parties must submit the arbitration agreement or clause so that we verify whether the dispute is arbitrable and whether the arbitration agreement itself is valid. So, once those two boxes are ticked, then like we're good to go. And a plus point at IAMC, I would say, is that, very early on, the parties get on an introductory call with the case managers. So they help them and they walk them through the entire arbitration process, the arbitrators that we have on panel, how the appointment takes place, the expected timeline, and the fee structure. So there are, no surprises later on.
That's
So
really good to know. It's really party centric, as you told earlier. So my next question is, how does IAMC ensure the impartiality and expertise of its arbitrators and mediators? What is the selection criteria that is used by IAMC?
Okay, so great question because that's actually very important to us, IAMC. So every appointment itself begins obviously with party consent, and once we have that, we initiate a conflict check. It's a form, and we share all the party details with the arbitrator or mediator, whoever's nominated, and we give them a very brief idea of the dispute. So once they ensure that there's no conflict of interest, they submit their statement of independence to us. And once that checks out, which is in alignment with the Arbitration and Conciliation Act, then we proceed with the appointment. And it's a similar process that is for mediators as well. So apart from this, a very important thing is what we are focusing on is the gender diversity aspect also. So I remember as of last year, we had a good 65% of our appointments in both arbitrations and mediations were women. So that's a statistic we're very proud of as well. Yeah.
Thank you so much. On that, I wanted to ask you this question only. How has IMC addressed the ongoing concern on lack of women representation in appointments, and in what ways it has contributed to advancement of gender diversity?
Right. So that's what, see, fairness, I would say it's a lot to do with representation. Like I told you, so what we realized in our last 3 years is there are not enough women arbitrators and mediators. So in fact, we've launched a new course for women in arbitration called it's for women who want to become arbitrators, right? So from different walks of life, we're doing a course for them. It's a rigorous 40-hour course with a lot of skills that we teach them about award writing, how to go about it, and then there's a assessment for them. After the assessment, we'll be empaneling them with IAMC and we start giving them smaller dispute matters, for example, smaller dispute value, for example, the MSME matters. And a lot of hand holding what we are planning to do. So this has been a very important initiative for us because to ensure this gender diversity. And other than that, we've been having a lot of conferences where even people like Justice Hema Kohli and all of them have come and spoken about the inclusion and empowerment of women. We've also tied up with the CII Indian Women Network, the Telangana Police Safety Wing here, to sort of understand the kind of issues they are coming across and train them about how matters can be referred to us for speedy resolution. Yeah.
Thank you. That's a great initiative.
Yeah, and I also want to add that actually, even internally, our staff, I think, is a good 70% women right now.
But that is bias against men.
That's another debate.
Yeah, sure. So what are some of the best practices for parties drafting arbitration clauses to ensure a smooth process at IMC?
Yeah, so this is very crucial actually. And at IMC, we've seen how well a well-drafted clause can actually make or break the efficiency of a proceeding, right? So what we recommend right now and what IMC is really pushing for is a multi-tier dispute resolution clause, the MEDAP clause. So it's one of the most effective trends, I think, and it's basically where parties first attempt mediation, and if that fails, then they move to arbitration. And of course, there are other hybrid clauses like ARB, MEDAP, but we are pushing for MEDAP because it's the basically it's much better to start with mediation than good faith negotiations itself between the parties. We really think mediation has been far more productive than just two parties negotiating when there's a neutral mediator. And the key is to build reasonable timelines for each step to avoid stalling. So even before your arbitration starts, depending on the matter, it's usually a 60 or 90-day period we give for mediation, and there are a lot of follow-ups, and we ensure that there is a mediation report by the end of it. So that's very important. And another suggestion I would say, what we've seen is that, when people come to us with their arbitration clauses, what happens is it's always silent on the number of arbitrators. So I would say when they're drafting the clause, it's important to maybe for smaller claims to mention that it'll be a sole arbitrator so that it's faster and more cost. It's to mention that it'll be a 3-member tribunal or whatever they deem fit. So that's something I would suggest that they have to keep in mind while drafting the contracts. And sometimes we've also seen that it's very restrictive, the criteria they have for the arbitrator appointment. So, for example, for international matters, it's very convenient for both the parties to just want a neutral country arbitrator who understands both legal systems. So they put that clause. But when it comes to practicality, it's very difficult for them legal processes of two different jurisdictions. So this is where institutional clauses would really be very helpful, and we have a model clauses which they can just copy paste and put it in their agreements. So having this institutional clause will just relieve you of going through all these wondering what to do, because it gives you the flexibility, it gives you the options. So then you can have people appointed from our panel, and we have a diverse panel of people from different regions. So it just sort of like narrows down a lot of time that you might lose if you don't have a proper clause. So these model clauses are something I would highly recommend if the agreements are not yet drafted.
Thank you. I think that's a very important discussion. Sorry, important point that you have raised. Uh, I believe it will be helpful for our viewers and people who are drafting arbitration clauses. So, in our discussion earlier, you spoke about yes. No, please
No,
continue.
instead of copy pasting it from a previous agreement or a previous contract, it's better to copy paste an institutional clause, because it just makes things a lot more easier. It just helps you prepare for things you're not anticipating, any challenges that you're anticipating.
Certainly, certainly. So yes, so as I was saying, as in our discussion earlier, you were speaking about emergency arbitration. So how does your institution handle issues related to interim relief and emergency arbitration?
Yeah, that's a great question, especially because in commercial disputes, timing can be everything. And at IAMC, we have very clear mechanisms in place for both interim relief and emergency arbitration. So once the arbitral tribunal is in place, like Section 9, Clause 3 of the Act says that courts should not entertain interim relief applications unless the tribunal the remedy from the tribunal wouldn't be effective. So parties can directly apply to the arbitral tribunal itself under IAMC rules. And IAMC rules mandates that any decision on the request for interim relief shall always be supported by reasons. So that becomes very important. And now, in case if an extremely urgent relief is needed before the tribunal is constituted itself, Then IMC has a dedicated process for emergency arbitration. So here, parties can file the emergency arbitration application along with their arbitration request, or right after that, before the tribunal is constituted. And we'll appoint a sole emergency arbitrator within 3 days from the request. And then the same process where, statement of independence has to be received. And once appointed, the emergency arbitrator has full authority to grant this interim reliefs also, right? So the entire process, and they have to decide the application within 14 days of the appointment. So within 14 days, you have your relief.
Thank you, Nikshita. I believe IMC has really done a great job and they are up to date with the international trends. So
Thank you. Yeah.
my next question is, as you know, cost is the king. So what are the costs associated with arbitrating at your institution, and how does that compare to the other options?
Yeah, I think that's very important because anytime you mention arbitration, that's the first thing that people think of, how much it's going to cost me, right? So cost, I would say, okay, first I'll speak about arbitration, then mediation. So for arbitration, your filing fee to the center would be this is very transparent. It's also available on our website. And then you have the administrative fee. And a very important thing that IMC has done is we've capped our administrative fee at 30 lakhs. No matter how massive your dispute is, even if it's a 1,000 crore dispute, the administrative fee is capped at 30 lakhs. So if you compare this to any other institutions, you won't find that because it keeps escalating with the dispute value. And then even the incremental costs that we have for really high disputes, say if your dispute is going over 5 crores, then we do apply a small increment increase. And it's very minimal in comparison to other institutions. So to like explain it better, I would say, suppose it's a matter that's the dispute value is between 5 to 10 crores, then your increment of the administration fee is just 0.3%. But when it goes from 10 crores to 50 crores, the increment is again just 0.2%. And more than 100 crores, it's like 0.05. And it gets capped at 30 lakhs. So that's a very, very affordable way of the way we've structured the fee when you compare it to other institutions where, it just keeps escalating basically. And even on the mediation fee structure, it's extremely simple and reasonable because the whole approach is to make it service oriented and to sort of increase awareness for mediation, right? So the filing fee is only 5,000 rupees. And once you do that, you have your administrative fee is minimum of 20,000 and I think a maximum of 1 lakh. So this is even for disputes over 50 crores or so. Your maximum administration fee is 1 lakh. And then the mediator fee is kept extremely reasonable. It's 7,500 per session, up to 5 crores. And if it's a matter that's exceeding 5 crores, it's about 20,000 per session. Per session is per 3 hours. So this is like kept extremely reasonable mediation. And of course, you have specialist mediators like international. We have a panel where there are people who've done international matters and their fee structure can always be discussed and decided. But this is what we follow generally.
Thank you, Nikshita. That's really nice to know. So, as you were talking about international mediators and arbitrators and institutional bodies earlier, so how does IMC engage with international bodies, and how does they adopt? Have you adopted the best practices from them, including utilization of technology?
Okay, so IMC within a short span of time has taken a lot of bold steps to establish itself on the global map, right? So this whole thing has been really aided by our trustees and registrars who have had that vision that, institutions have to collaborate and work together and they just have to sort of make the pie larger kind of an approach. So we have entered into a lot of MOUs with leading institutions such as Singapore International Mediation Center, Dubai International Arbitration Center, Russian Arbitration Center, China, CTAC, and institutions in Malaysia. So these partnerships are extremely important because they go beyond formal agreements. They are basically initiatives where we are willing to do conferences, workshops, training programs to understand what's happening on the global scale and what are the standards and efficiency methods that people are using worldwide. And we also have in some of our collaborations where members from their panels can be recognized by us, and our people who are empaneled with us will be recognized by them. So all these are very important and strategic because I mean the approach of IMC is not only international, but it's to be strategic in these terms. And even our governing council, for that matter, it includes renowned experts in the ADR field from across the globe. So they have played a key role in preparing our policies, our rules. So they are obviously very well equipped, and them preparing our rules has been a very important factor to us. And also, I mean, international, yes, but also we also looking at how what are the best practices for local and regional relevance, because in India it's very different to reach to the grassroots levels as well. So there are a lot of strategies on that front too. So technology has become extremely important for us because on one hand we have to keep up with that, but on the other hand, on the local and regional level, we also have to make sure that it's extremely simple, the technology, so that everybody can use it.
Thank you. As you were talking about strategy and initiatives, so what are the future plans on the horizon for IAMC?
So yeah, I think the primary goal I would say is to position India and especially Hyderabad as the hub for both domestic and international mediation arbitration. And so we are obviously trying to bring in matters, international matters here, making India the go-to destination, because right now it's important to show that we have institutions which are credible, so that people do approach India, because there are a lot of stats which say that a huge chunk of disputes, contracts in India, where at least one party is an Indian party, they go to Singapore and London, right? So we need to build that trust in Indian institutions. So to ensure this vision is becoming fruitful, it's important that we work with the government here. We are contributing to their whole ease of doing business initiatives, and also focus beyond the big cities, even the tier 2 and tier 3 cities. We've been doing a lot of roadshows, carried out more than 15 or 16 roadshows to give them the awareness. And another very important factor that our current registrar is focusing on is the outreach programs, the trainings and capacity building workshops, even at grassroots level. So we are targeting different sectors. So whether it's community mediation, whether it's MSME, small businesses, the startup communities. So we're reaching out to them sector wise, so that we understand if there are any sector specific issues and how exactly to help them resolve their disputes. And on the are coming up, because quality is something we're focused on. So even before empaneling people, if we are doing a training, we are ensuring we're doing a assessment, a very critical assessment. So that's another thing. And also on the ODR front, we're working with different technological platforms to see what fits our requirements correctly. So working with different people to make sure everything is seamless, even, and ensure that because confidentiality is important for us. So we are trying to make sure that even privacy concerns are taken care of when we're using technology at this point. So I would say it's 3 years, but a lot is happening, and I would say it's looking really good. A lot of exciting things happening.
Thank you so much, Nikshita. It was really an enriching session. I'm sure our viewers and everybody interested in arbitration and mediation uh, will know a lot more about IAMC and make and India, and will look forward for making India as an international mediation and arbitration hub. And great work. Thank you so much. I'm sure
Well,
we will also be working with you soon.
definitely, I hope so.